Let's talk about cross-examination of witnesses in court. And to start, let's talk about how it differs from direct examination. In direct examination, an attorney selects witnesses that attorney would like to bring to court to testify as to the facts that they observed. That attorney will prepare those witnesses, and then when they get to court, will ask open-ended questions and allow that witness to tell the tale of the case. The witness is basically telling the story, and the attorney is simply guiding the witness along to ensure that everything that should be covered is covered. Direct examination in the American justice system is followed by cross-examination. In cross-examination, the opposing attorney, the attorney for the other side, gets to question that witness who was just questioned on direct examination by the attorney who proposed the witness. In cross-examination, the attorney is allowed to use leading questions. These are questions that suggest their own answer. In fact, they're not very much like questions in normal conversation. They're much more like statements. An open-ended question suitable for direct examination might say, what color was the stoplight when the car went through it? And the witness could answer that any way the witness wished. There's no suggestion by the attorney as to what color the witness should say. In cross-examination, the attorney would say, the light was red. You see how that's really a statement, other than the fact that I went up a little bit at the end to give it the sound of a question? That's the way cross-examination usually works. The attorney simply makes statements and asks the witness to agree or disagree with the statements. In this way, the attorney controls the testimony much more tightly than what is done in direct examination. And that's usually necessary because, remember, these are witnesses from the opposing team. The attorney typically in cross-examination will seek to highlight any facts that were brought out by that witness on direct examination that support the cross-examining attorney's case, challenge testimony that harmed the attorney's case, and bring up any kind of general challenges to the witness's credibility that might be appropriate. The general categories are perception, recall, and bias, together with witness defects like a criminal history that a witness might have. Perception is challenging whether the witness could see, for example, what the witness claims to have seen. Say it was a drug deal and it was at night and it happened very quickly and the witness was some distance away and there was fog or something like that. It might be difficult for the witness to have seen what the witness claims to have seen. Recall is a suggestion that the witness has changed the witness's account or simply forgotten what happened at the time of the incident. Bias is typically questions relating to something like the witness's relationship to one of the parties. Maybe it's the witness's spouse or parent or child. And then, as indicated previously, witness defects could be something like the criminal history of a witness, for example. So that's a quick nutshell description of cross-examination. I hope it's been helpful. Thanks.